so for contracts today, we talked about unilateral agreements, which is different from bilateral agreements. If you take the roots or the Latin roots of words, bi means two, uni means one, and consequently, what you can infer from that is a bilateral agreement requires two promises, whereas a unilateral agreement only requires one promise. And I probably didn't explain that very well, but getting into it, a unilateral agreement is just a one-sided promise saying, I will pay you when you complete this task. So say I want somebody to paint my house. I would say to them, once you finish painting my house, I will pay you $1,000. Instead of saying, so that's the unilateral agreement. The difference between unilateral and bilateral is that bilateral says, I will pay you $1,000 for painting my house. So it's the difference of when the performance or when the promise is made. So the issue that this presents is, an offerer, where me saying I will paint your house, an offerer can revoke that promise at any time up until the performance is completed. So say you're painting the house. I offered you $1,000 to paint the house, and so you're painting the house and you're almost done, you're 95% done, and I come outside of the house with a glass of lemonade in my hand, and I'm looking at your work and I'm like, looks pretty good. I revoke my offer. Well, I am perfectly within my right with a unilateral agreement because the performance has not yet been completed. I said that I would pay you to finish painting my house, and you agreed to that, but you didn't finish painting my house, so I don't need to pay you the $1,000 for painting my house. So that's how unilateral agreement works, and really that's a flaw of the unilateral agreement because the offeree is at an unfair disadvantage, while the offerer is at a fair advantage. Now, what are some things that you could do to protect the offeree in this situation? Well, there is a principle that is kind of established where it says if there's a substantial performance, meaning if enough of the project was done, so to speak, you would pay them up to that substantial performance. And this is seen in one of our cases. It was a real estate case in Cook versus Coldwell Banker / Frank Laban Realty Co. What happened in this situation is that it was a bonus incentive program given to the employees to the real estate agent saying, if your commissions reach this level, we'll give you a bonus. If your commissions reach this in-between level, we'll give you a bigger bonus. And if they reach this final level, we will give you this additional bonus, all contingent upon the level of commissions that you make for us. So, in this instance, a party member, one of the real estate agents, made quite a bit of money, and the bonus was to be paid out at the end of the year. And then the real estate company in this said, okay, no, we changed our mind. We're going to, you need to be present to collect the bonus in March of the following year. And the real estate agent at the end of the year ended up leaving the company, and so they couldn't collect their bonus. They sued because, they wanted their bonus, and the defense was, we can revoke our offer at any time. And the court says, no, because there was a substantial performance that occurred in between. So they had met the levels of the commissions plan by their substantial performance. They had substantially performed enough to actually receive the promise, meaning that it was binding. The offerer is always going to be bound once the performance has been made. A good example of a unilateral contract is a bounty hunter. One of the characteristics of a unilateral contract is that many people can try to perform. So, for example, say the government wants to catch this fugitive, and they put out a notice to all the bounty hunters, saying the first one to bring him in is going to get $1,000. And they're like, sweet, I'm in. I'm going to go look. The thing with this is that only one person can actually catch the bounty hunter. There's only one person who's running away. Only one bounty hunter can catch the fugitive. There's only one fugitive in this situation, and there's only one bounty. So there's going to be 10, 15, 20, even 50 people looking for this fugitive, but only one person is going to actually be able to collect that bounty. That's another risk that you run with a unilateral contract. So whenever we're looking at a unilateral contract, we're going to say, what would a bounty hunter do? We're going to say, if this follows the situation where anybody can try and perform, the promises by the offeree are unhelpful, meaning a bounty hunter can promise that he's going to try and look, but it doesn't matter if he promises to try and look. He's not going to be paid for just looking. He's going to be paid for bringing the person in. And then also the only one performance can be rewarded. Only one bounty hunter is going to be paid for the work. Those are the three characteristics of a unilateral contract. So we went over a couple of examples. Bounty hunters are examples. Real estate agents are examples. And returning lost items, meaning I lost my pen, I will pay somebody to find my pen. Anybody can go and look to find my pen. Those are all examples of unilateral contracts. And we will want to try and avoid a unilateral contract if at all possible, because they're shaky. They don't really benefit the offeree, and they don't really benefit the offerer if there is a substantial performance requirement. So if at all possible, try and establish a bilateral contract, which is where the promises are made in advance. I will pay you $1,000 for painting my house. Not when you paint my house. I will pay you $1,000 for painting my house. And that is everything that we really focus on with unilateral contracts. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is, if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is, if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.